Good afternoon, everyone. My name is Joe Reed, and I welcome you today to our Vancity's 2023 Financial Literacy Month series of webinars. I am the Vice President of Wealth Management here at Vancity and Impact Investing as well. And I'm actually joining today from our head office at 183 Terminal, which is on the traditional territories of the Squamish, Musqueam, and Tsleil-Waututh Nations. I'd like to take a moment to pay respects to the elders past, present, and emerging, for they have been the custodians of this land for generations. And it is truly an honor and a privilege to work, live, and play on their lands. So November is a time where we have been proud to host a webinar like this one every single Thursday during the month of November for Financial Literacy Month. We focus on topics such as estate planning, like today's webinar, retirement planning, and investments in the markets. Today's webinar is on legal aspects of estate planning, and it's a very, very important one, and we hope that you will gain useful knowledge out of this. This is also the final webinar in our series that we've been doing over the last little bit. Having said that, we're already hard at work at preparing webinars that we will bring to you starting in January 2024. I would encourage you to share with us some topics that you feel would be helpful for yourself, your friends, your family, and your communities. Your feedback is welcomed as it helps us to make sure we are providing you the info that you need most. This webinar is going to be recorded and it'll be shared with all registered attendees, and it will also be posted to our YouTube channel following the event. If you haven't already, please make sure you follow Vancity on YouTube and our various other social media platforms like TikTok, Instagram, or Facebook, and get connected so that you can get access to great content like this webinar. And finally, we encourage you to engage with us throughout the webinar. Take notes as you go through of maybe some of the most valuable information that is there and what will be most helpful to you and your family. The question and answer button allows you to submit a question at any time, and we will be making sure that we are answering those questions following the presentation itself. With that, I'd like to take a moment now to introduce our speakers to you. First, we will hear from Catherine Kim. She is an estate and trust lawyer with Boughton Law, and Catherine practices in estate and trust planning as well as estate administration. She focuses on personal estate and business succession planning and advises on matters such as wealth preservation, probate minimization, and incapacity planning. Catherine's background in tax also equips her to navigate various income tax and regional real estate tax issues and to provide comprehensive solutions that complement her extensive background in estates and corporate law. She works with accountants, investment professionals, and other advisors to implement proactive and practical solutions for individuals, businesses, and professionals of various disciplines. You will also hear from our own Linda Deer. Linda is the estate planning consultant with Vancity. She's been with Vancity for 26 years in the Estates and Trust Department. Linda has worked with our members on estates from both the planning and advice side, as well as from the administrative side of estates, trusts, and powers of attorney. Linda has gained insights from both sides of the equation, as well as from her legal training and experience in the public and private sectors. For the last 6 years, her focus has been exclusively on the advisory side, working with our members and our staff alike, spreading the message on the benefits of estate planning and how to make and execute an effective estate plan. Following the presentation from our estate experts, Barry Osmond, our manager of Vancity Investment Management, will be moderating the question and answer period and will also be providing closing remarks for you. So with that, I'm going to turn the microphone over to Catherine, who is going to start to walk through.
Thank you, Joe, for the kind introduction, and many thanks to Vancity for having me this afternoon. So today we'll be talking about the legal side of estate planning. And this slide goes over the 3 fundamental estate planning topics that we will cover today: wills, power of attorneys, representation agreement, and joint ownership. Our discussion is also going to include common myths about these topics as well as common pitfalls. In the interest of time, I'll go through my slides fairly quickly, but I understand these slides will be available for you after the presentation. Next slide, please. Before we dive in, this chart shows when each of a will versus a power of attorney versus a representation agreement takes effect and what it does. Note here that a will is only relevant on death, and before then, it's a power of attorney that governs your assets and finances, and it's also a representation agreement that outlines who is your spokesperson for making personal or medical decisions on your behalf. Next slide, please. You are likely familiar with these basic facts on wills. What you may not know is that BC is fairly unique in that a will can be challenged by certain people after the will maker has died. Namely, if a surviving spouse of the deceased or a surviving child of the deceased is unhappy with what they've been left in your will, then they have the ability to challenge the terms of the will. And for clients considering leaving their children unequal amounts, or clients with blended families who want to be strategic about what to leave for their children, it's helpful to obtain legal advice. A question that I often get is, what is the difference between having a will prepared by a lawyer versus a notary? And so I'll stop here to walk through the explanations that I most commonly give. So number one, notaries are not permitted to provide legal advice. And so we talked about the ability for a person to challenge a will. So in that scenario, a notary is not equipped to advise on the strategies that can be taken to reduce the likelihood of a will's challenge. Lawyers also know what questions to ask and how to implement certain legal strategies to best protect the will as it's written. Another important distinction is that notaries are not licensed to create trust terms in a will. So for example, if you've got beneficiaries who are minors, so under 19, or perhaps even beneficiaries who are older or under a legal disability who may need trust terms, a notary is not equipped to draft trust terms in a will. Another difference is for clients who are perhaps elderly or who have diminished capacity, notaries are not qualified to assess whether a client has the legal capacity to create a will. And this is important because if a person creates the will without the minimum level of mental capacity to do so, then that will can be struck down as invalid. Now, the chart that we're looking at is what happens on the death of a person if they pass away without a spouse or children who survive them. So the key takeaway here is there is a priority sequence of people who will inherit. So in that scenario, the deceased assets would first go to any surviving parents, otherwise to surviving siblings, and further to any surviving children of those siblings. And ideally, you would have a will to rule out the worst case scenario of your assets being forfeited to the government because there are no surviving family members. Next slide, please. Now, if a person passes without a will, but they do have a spouse and children, then there are default laws in BC that specify who gets what. And the pattern of distribution is going to depend on whether the children of the deceased are also children of the surviving spouse. And if not, the spouse is going to receive different amounts. And another key notable is that any spousal home owned by the deceased would go to a spouse. So generally speaking, the spouse gets the spousal home and they do get a priority and a higher amount of the other assets. A significant drawback to relying on BC's default rules is that this can often lead to a premature distribution to children So typically you want a surviving spouse to be able to inherit everything rather than having a portion of your assets go to your children. And even if your children are over the age of 19, depending on the value of assets, 19 might be too early of an age for your children to receive outright. The one benefit, if you could call it that, to not having a will is that there is no risk of a wills challenge unless there's an actual will. Next slide, please. This slide gives you a visual of the certain types of assets that pass under a will versus assets that pass outside of a will. So it's a common myth that your will governs everything that you own on death. But the truth is, your will only governs assets that you are the sole owner of. Now, the importance of that is what's governed by your will is what is subject to probate fees, which in effect is BC's form of estate tax. And currently it's charged at 1.4% of the value of your assets. And so there's a lot of motivation in BC to minimize probate fees. And I'm going to defer to Linda Deer's presentation on different strategies to minimize probate fees. Next slide, please. Another common question I get is when to update a will. So a common myth is that once you have a will, you can rely on that will for years to come. But creating the will is only the first step. And we advise clients to review their wills, power of attorneys, and other estate planning documents every couple of years to see whether changes are appropriate. And so what you see on this slide are common life events that can trigger an update to your will. So what you don't see here is that laws do change from time to time. So if any of these apply to you, that might cause you to go see a lawyer to update your will. And as a lawyer, what we typically do is we sit down, we do a comprehensive review of your documents, and we flag for you other considerations, other refinements, or planning opportunities that you can consider if you're going to be updating your will anyways. Next slide, please. Now, this is regarding planning for incapacity. I'd say there are a number of clients who have wills, but who have not necessarily turned their mind to what if they lose mental capacity during their lifetime and they're no longer able to manage their day-to-day affairs. And so this can happen regardless of age, health status, or anything like that. And so we generally recommend that when you have the will, you also consider having a power of attorney and representation created. And going back to the chart from earlier in the presentation, the difference between a power of attorney and a representation agreement is that a power of attorney is appointing a person to manage your financial and legal matters, whereas a representation agreement is different in that it appoints someone to deal with the softer decisions. So things like personal care, medical care, details including end-of-life measures, if, when, and what type of long-term resident care to move into, and so forth. Next slide, please. Going into power of attorneys in a bit more detail, there are two main forms. The main form of attorney is called a springing attorney. And so this is a power of attorney that only activates if a certain event happens. And that certain event typically is only if you lose your mental capacity. And so a power of attorney of this kind is activated with a doctor's confirmation that you've lost capacity. The other is an enduring power of attorney. And this document is effective as soon as you sign it and your appointed attorney signs it. In recent years, enduring power of attorneys have become far more common than springing powers of attorneys. And the practical reasons for this include that these power of attorneys can be used for convenience. For example, if you are traveling overseas and you need matters here in BC dealt with by a trusted person, that person can go and deposit that check for you or sign that legal agreement for you. The other consideration is that The doctor's note needed to trigger the activation of a springing power of attorney has become a lot more difficult to get a hold of. And so because there has been a lack of family doctors who can be seen urgently, or because power of attorneys, when used, typically have to be used right away, we have generally recommended to clients to opt for an enduring power of attorney instead of a springing power of attorney. A lot of couples ask whether a power of attorney is still necessary if they own assets jointly. And in fact, joint ownership is not a substitute for a power of attorney, because a power of attorney gives you the ability to sign on behalf of a person. So if you own a house jointly and one of you is going to be away on the sale date of the house, the power of attorney is needed for you to sign on your spouse's behalf. And joint ownership is not sufficient to get you there. And in an absolute worst case scenario, if you've lost mental capacity and there's nobody appointed to deal with your assets, then the law does not give that authority to anybody automatically. So not to your spouse, not to a parent or an adult child. There's just simply no one with authority. And in that case, a next of kin must apply to court to apply to become formally recognized under what's called a committeeship agreement. And so this is applicable if you don't have a power of attorney. The cost of getting a power of attorney, or getting a committeeship application and order, ranges at minimum of about $5,000 to $10,000, and a substantial portion of that cost is the medical doctor's opinion regarding incapacity. So it typically is a no-brainer to spend the funds on a power of attorney to cover your bases. We also warn against hiring or appointing a US person, if at all possible, because the appointment of them under a power of attorney can trigger filing requirements and information disclosure to the IRS, which ideally we would like avoided. Next slide, please. This slide shows common uses of power of attorneys, so day-to-day needs, but also more important things like signing agreements, loan agreements, sale agreements, and things like that on your behalf. A really important thing to consider is that if you want an ability to have assets gifted out of your estate, there's a limit on that of up to $5,000 per year. And that can be sufficient in some purposes, but not for others. And so when you see the most common type of 1 or 2 pager power of attorney, the document simply says, I appoint my attorney to do anything that they're allowed to do under law. But almost always, a person that's appointed has no idea what they're allowed to do under law, and they don't know the specifics of what they can versus cannot do. So what we like for our form of power of attorney is to be able to specify the kinds of things that can or cannot be done to make it a bit easier for the attorney to exercise their powers. Next slide, please. So this is a further summary of what an attorney cannot do. Now, when you appoint someone, you're going to appoint someone who's very trusted, because the assumption is they can largely do whatever you could do other than rewriting your will. So it's quite an important document. We also talked about specific powers and that limit of gifting no more than $5,000 per year. And so you may want to create custom clauses for things like being able to gift amounts of money beyond that amount, making charitable donations, especially for tax planning reasons at the end of the year, borrowing funds, granting guarantees, or the ability to enhance your estate plan through the use of trust, like alter ego or family trust. And for people who have company shares, an express ability in the power of attorney that discusses the ability to tax plan can also come in handy. Next slide, please. So for those who have a power of attorney, the question to ask is your existing power of attorney sufficient? And in a lot of cases, it might be. However, there are certain situations, for example, where you are giving financial assistance to other members of your family, or where other members of your family are occupying a home or other real estate property that's in your name. You may want to revisit whether your power of attorney contains the proper terms that allow for your assets to continue to be used and for financial assistance to continue to be granted even after you lose mental capacity. Next slide, please. And quickly touching on representation agreements. So I like to call this a power of attorney for health and personal matters. And so there are a couple of different versions. We recommend a Section 9 agreement, and a Section 9 agreement focus exclusively on personal care and medical decisions. And our form of power of attorney includes a list of procedures that your appointed person can consent to or refuse as your health spokesperson. And end-of-life measures has become a common topic of discussion, as well as you may have heard of MAID, medical assistance in dying. And so the laws as they are today don't allow a person to delegate the ability for MAID as a procedure. However, we anticipate that in the future, you may be able to allow someone else to apply for MAID on your behalf if you've lost capacity. So our documents contain terms that allow a broadening and a change of those rules in the future. And the materials also include considerations for your representation agreement and a link to the complementary provincial version if you'd like to review the common terms that can be considered in a representation agreement. Next slide, please. So I will spend the final 10 minutes or so of my presentation discussing joint ownership. Now, joint ownership is a hot topic with virtually any estate planning client that we have, commonly because of the probate fees that I discussed earlier in the presentation. So the benefits of joint ownership include that you can potentially avoid probate fees on any assets that you add a joint owner to, and it can streamline the transfer of assets process after you've passed away. Now, a common myth is that there's only one type of joint ownership and that it's a one size fits all. However, there are actually 3 different types of joint ownership, and I wanted to flag each of those for you today. Now, the first is what we call a true form of joint ownership. Now, this exists only between spouses. So anything that's jointly owned between spouses on the death of one spouse will automatically pass to the surviving spouse. Now, the laws of true joint ownership do not apply to a parent and child. So when a parent and child, even an adult child, are joint asset owners, there is no assumption that if the parent dies first, the asset will automatically pass to the child. That assumption only exists if there is a document or some other evidence showing that that's what the parent intended to do. So without any further documents, when we see an asset owned jointly between a parent and an adult child, we assume that this is a for convenience only type of joint ownership, where basically the asset is 100% owned by the parent, and even after the parent's death, that asset will continue to be 100% owned by that parent's estate, and that asset must be distributed under the will of the parent, and that asset is disclosable and subject to probate fees. So any parent and child wishing to consider a joint ownership structure should get advice on the proper additional documents needed to make this a true joint ownership if that's what the intention is. And so if the goal is for the parent to gift an asset to a child outside of the will after that parent passes away, then the key is to specify the right of survivorship on death. So the right of survivorship is the specific ability for that child to inherit the asset if they outlive the parent. So the key takeaway is to put your intention in writing, specify the type of joint ownership that you intend, and know that the form that you fill out with Vancity, including any boxes that you tick, recent court cases have said that those forms are typically not sufficient, and there has to be another document, such as a gifting document, that specifies the type of joint ownership. Now, there's a number of pros and cons, and we talked about the pros being reducing probate fees, avoiding the probate process, which takes several months to a year, and reducing the risk of wills variation claims. But there are a lot of drawbacks that a lot of clients don't consider. And if you're working with, for example, a notary may or may not be aware of the laws. And technically, notaries are not qualified to give legal advice on whether a joint ownership structure is right for a client. So these are the list of cons to consider. The big one is that once you add someone as a joint owner, there's no going back. That gift is irrevocable. And so you have potentially lost control of that asset, and the joint owner that you've added can go ahead and do things. And also, if you want to go ahead and do things, that joint owner's signature, permission, and involvement is going to be included as well. The other common pitfall that clients walk into is accidentally limiting the principal residence exemption. So that's the exemption that protects a home from capital gains tax on sale or death. And so a lot of people accidentally trigger that too early. And the result is capital gains are triggered and payable on the sale of a home sooner than the homeowner intended. So we walk clients through the long list of potential pitfalls with joint ownership. And the assumption is that joint ownership is not right unless the client convinces us that they're aware of the risks and that they think it's suitable for their family. Next slide, please. Now, what's brand new for 2023 is reporting obligations. So reporting obligations refers to filings with third parties that you have to make as a result of joint ownership. And there are different reporting obligations depending on the type of asset that you're putting into joint ownership. So for bank and investment accounts, it can be limited to this income tax return for bare trusts. And whether that's relevant depends on whether $50,000 is in the account at any point in the year. So even if for one day of the year, the balance of a joint account reaches that $50,000 mark, that in itself triggers the requirement to file a bare trust tax return. So that $50,000 figure is a very important magic number to keep in mind. More commonly, if you're considering adding a joint owner to real estate, such as a home, we have not only an income tax return for bare trusts, but also several real estate specific acts that require that you disclose this joint ownership for estate planning purposes. And so as you see the list here, the random alphabet soup of the various real estate laws that apply and that have to be paid attention to. And many of these real estate laws include annual filings that you and the joint owner have to be responsible for. And what's tricky is there are a lot of joint owners out there who have already added a family member as joint, but they may or may not be aware of these new rules. And so if they've done this structure, but they don't comply or file the necessary returns, and later on, a provincial entity finds out that a joint ownership structure was intended, significant penalties can apply for a failure to disclose the joint ownership. So we encourage you to seek advice on whether you may need to file under either of these categories. And so a key point also, just like how a joint ownership is not a substitute for power of attorney, a power of attorney is also not a substitute for joint ownership. So with joint ownership, you can't transfer real estate between each other. You can't file a tax return for a fellow joint owner, and you can't open new accounts for a fellow joint owner. So for all of that, you would also need a power of attorney. So for clients that we implement joint ownership planning for, the pieces of the puzzle include the joint ownership documents, plus a valid power of attorney, plus a valid will. So none of these are substitutes for each other. They all create a comprehensive plan, and each piece is important for a different reason. So that concludes my high-level overview of some fundamental estate planning topics. And with that, I will turn the mic over to Linda Deer.
Thank you, Catherine. I'm here to talk today about more of the estate planning, practical and personal aspects. So Catherine had done a really good job about talking about the legal aspects of estate planning, but really the estate planning starts with personal matters and decisions that you're making. So I'm going to talk about that. Such things that I hear about is, when should I make my estate plan? One word answer for you: now. It is a good time to make your will now. If you are over the age of 16, there's no reason why you cannot have a will in place, which is the start of your estate plan. Now, Catherine mentioned other aspects of an estate plan, and we'll go over some of those as well. But we want you to be able to make the decisions that you have. If you want to talk about those legal defaults, they are kind of like the framework of your estate plan, potentially. They can set the structure, but what is part of the plan itself is really personal. It's about you, it's about your life, it's about your death and your family's life. So, you want to make your own decisions when you can and when you have the ability to do that, rather than have somebody else make those decisions for you, and also have the law or other defaults in place, which may or may not suit your wishes. So there's no reason to wait for making your estate plan. Now, Catherine had mentioned about probate and probate fees, and yes, I get a lot of questions and concerns about how do I eliminate or avoid probate and probate fees. In some cases, you might not be able to completely avoid it, but there are some things that you can do to potentially reduce the probate fees in your estate, for your estate. One of those is joint assets, which takes assets outside of your estate potentially. But again, has to be a true joint tenancy, as Catherine mentioned, for that to happen. So for spouses, yes, it works really well. But for anybody else, I would say there's red flags there and cautions to be taken. So you really need to talk about that with a legal advisor to make sure that that works for you and that is appropriate for your situation. Something else that you can do to take your assets outside of your estate is through beneficiary designations. And I really suggest that you take advantage of that whenever you can. So you'll be probably aware that on your registered products, on your RSP, on your RIF, on your tax-free savings account, you can name beneficiaries directly. And that's a lot easier to do than joint assets. You're going to run into a lot less or fewer problems through those beneficiary designations than trying to add a child as a joint owner with you. So take advantage of that. Also, we have advanced gifting, and what that is distributing some of your assets while you're still alive. You can make a gift of some of your holdings or your funds to people that you want to benefit, your children, perhaps your grandchildren. And again, that will reduce the amount of the assets that are in your estate at the time of your death. So that's one way of reducing the probate fees, because the probate fees are based on the total value of your estate at the time of death. Now, another strategy for removing assets from your estate is through trusts. So like an altar, quite a bit more complex than having a will in place. So that's something that's not, again, applicable to everybody or even suitable for everybody. So you really do need to get good advice before taking that step. Legal advice is strongly advised. And then the other, another way of reducing the estate assets potentially is if you have private company shares. Again, that's a little bit more complex situation, and you do want to see a lawyer about that. You can potentially reduce your probate fees through multiple wills. So having separate will to deal with those private company shares. But again, you need legal advice to have that in place and to make sure that the wills that you make are appropriately made and clearly stated and do not accidentally revoke each other. So that's something that you could keep in mind. Now, one bonus tip that I'm going to give you today is for spouses. You're not going to hear this from probably anybody else. It's just something that I talk to people about, and it's from personal experience and also from experience that I've seen at branches and questions that I've had. So mostly we have spouses with joint assets, which is a good thing. We want them to have that. Makes things easier. They avoid probate. But they often end up with the deceased spouse having checks come to them. It might be for refunds of services that have been canceled or for tax refunds or whatever things that come through, and they're payable to the estate of the deceased spouse. Now, what happens is when you have a joint account with your spouse, once you die, that's no longer your account, and we cannot deposit funds into that account for you, and we cannot deposit the estate account, estate checks into that account. So that poses a problem. I've seen that many, many times before. I get calls from the branch and members come in with a check and we can't deposit it. What do we do with it? Happened with my own father's estate also. We received some checks. Again, minor checks, but still, they are something that we can't deal with. No place to deposit it to. So my suggestion is for all spouses to maintain at least one sole banking account. One is good enough at Vancity for dealing with those additional assets or checks that come in. That way you can at least deposit them, and as long as they remain under a certain value, for Vancity it would be $30,000. We won't require probate to deal with that account. You can close it out once you need to, but we suggest that you keep it open for probably a year, because there will be these checks coming in over that time frame. And once you do your tax return, you'll get a tax refund potentially as well. So that is my extra tip for you to do that. And that's just a practical matter. Beneficiary tips also for you. Again, use those beneficiary designations. But again, we have some things that you want to be aware of. So again, it's a very good plan to name your spouse as the beneficiary of your registered products. There's tax benefits for doing that, for deferring taxes or making sure that you don't have to pay taxes right away when you pass away, because we have something called deemed disposition, and you could be in for a lot of taxes at the time of death. But for spouses, it can defer those taxes for you. There's ways of doing that. One thing I do caution you about is no minor beneficiaries. Do not name your minor children as beneficiaries on anything, on your RSP, on your tax-free savings account, or even on your will even. You want a trustee in place. Your child cannot receive assets while they're minors. Once they're 19, that's fine. You can add them on there and you can name them directly as your beneficiaries. But you might still want to have a trustee because, again, some people and most parents will probably think, it's not a good idea to give a 19-year-old a large sum of money. They're probably not able to deal with that. So not a good idea. You might still want to use a trustee anyway. Also, if you have beneficiaries who might be persons with disabilities or receiving disability benefits or have mental health issues or substance abuse issues, you again might not want to be giving money directly to them on your death. So you might want to have a trust in place for them as well. So that's another way of holding back some funds or distributing them over time or in a different way than just one lump sum at one time. Another thing you might want to consider is having alternate beneficiaries in place. So in case the first named beneficiary is not alive at the time to receive that payment from that asset, then you could have named an alternate in place there as well. Now that may be or may not be appropriate. Again, there may be circumstances where you want to do it a little differently. If it's an RSP, for example, you can name a child as a beneficiary and that will work. But if your child dies before you, it could one default back to the estate, which would be okay, could be okay, or you could name an alternate. But again, it depends on your circumstances, how you want to have that distributed and who is going to be receiving that, whether it's appropriate to run it through your estate, maybe through a trust in your estate and your will, or leave it to just the alternate on the plan. So next tips would be about executors. And so the executor is the party who is legally responsible for winding up your affairs and your estate for you, administering your estate, gathering up all of your assets, paying all your debts, liabilities, and taxes, and then distributing the net or the residue of your estate to your beneficiaries. So I would say that's a really important job. It's a really responsible job for somebody to take, and it can take a while. So even with a regular, you think it's not a big estate, it's nothing complicated, it could take 2 or 3 years for that to run through everything, including all of the taxes and everything that needs to be done. So you want to choose wisely as to who you want to have responsible for that. You might automatically think, well, I would name my child. But, you know, your child could be somebody who's wonderful. He's great, you know, but if they're interested in doing things with their hands and working outdoors, but, you know, numbers and things like that, just not their thing, that person might not be the best person to name as your executor. So maybe it would be somebody else who would be better suited for that. Naming a non-resident, if your children live outside of the country, a lot of times they now move outside of the country. It may not be such a good idea to name that person. There may be tax consequences that have application there. Multiple executors. Should I name one person or all of my children? Should I name all 4 of my children as executors? Maybe not. It gets more complicated. Maybe with 2, at least they could support each other or help take some of the load off the administration. But the more people you add on there, the more complex it gets. Everybody has to agree to everything. They all have to sign everything. They have to get together and so on. So again, just think about that. Is that really something that you want to do? And what kind of qualities are there that you want to think about in an executor? What's their skill level? What is their knowledge? Do they have an aptitude for all of the financial things that need to be done, all of the record keeping, all that needs to be done, all of that kind of thing? Are they available? Are they in the country? Are they, do they have busy lives? Do they have jobs or families that will not allow them to spend a lot of time working on your estate? Are they trustworthy? And the other thing that I would suggest is make sure you pay your executor. Every executor is entitled to a fee for acting as an executor, whether it's your family member or a corporate or executor who is a trustee, trust company, for example. But if it is a person that you're appointing, do make provisions for the fees in the will itself so that they don't have to deal with any of the problems afterwards about how much they will take and whether it has to be approved by all of the beneficiaries or if it has to be approved by the court. Those things are extra steps and potentially more expensive to be dealt with as well. And in some cases, you might want to consider having a professional executor in place. That is also another option. Next slide, please. And then just to finish up, I'm just going to go over the top 5 reasons for making your estate plan. These are my top 5. So one is it will just simplify the estate administration for your family, really make things easier for them. And 2 is to clarify and express your wishes. Again, don't let the default terms govern your estate and the distribution of your estate assets. You can reduce taxes sometimes, like the probate fees, by structuring things in a way that works for you and reduces the amount that you have to pay. You can potentially avoid conflict, like not naming all 4 of your children as beneficiaries or as executors, for example. So things like that you can do as part of the planning process. And then the number 1, I think, reason for having your estate plan in place is, and what I hear a lot is just peace of mind. So you don't have to worry about what's going to happen if something happens. If you're going on vacation and you're in the plane and you think, well, if this plane drops out of the air right now, at least I know my kids are taken care of and that they will have what they need. So That is what I hear a lot from people, that once they get over the procrastination and the worry about getting things done, once they do it, they are relieved and have that peace of mind. So that's my top 5 reasons for actually having your estate plan in place. And that pretty much winds up my presentation for today. So I will pass this back to Barry, who will deal with some questions and also some wind up for us.
Thank you, Linda, and thank you, Catherine, for the informative session so far. We have a number of questions coming our way. So, Linda, I'm going to maybe pass the first question on to you, since you're just going over that topic here. You did mention naming siblings for as executors and how that could potentially pose some challenges. Are there any concerns when it comes to naming siblings as powers of attorney?
Probably the same issues that it's probably the same issues that you would have as naming an executor. So are they appropriate? Do they have the ability to manage the role and to take that on? Again, there's a lot of financial issues that need to be dealt with, tax issues that need to be dealt with, just everything that need to be kept up to date and in place. And especially with the power of attorney, really the power of attorney requires that the attorney keep detailed records of every transaction, everything that they do. So, you know, if somebody's not good with that, then that might not be the best person to name as a power of attorney.
Thank you for that answer, Linda. Catherine, the next question comes to us regarding inheritance tax and how one can minimize it. The question is, when I inherit from my parents, how do I minimize my inheritance tax?
Okay, I'm happy to address that. And so the term tax is an umbrella term, and it includes a variety of different taxes, so to speak. So when a person dies, that can trigger capital gains tax, which is reported in your income tax return. But if you've got a surviving spouse, typically anything that goes to the surviving spouse, the tax is deferred until that spouse passes away. But as you've flagged in your question, by the time you're inheriting from your parents and the assets pass from one generation to the next, capital gains tax is typically the biggest tax that you're looking at. And so capital gains tax doesn't apply for principal residences if they meet the qualifications of the principal residence exemption. So making sure that you protect that principal residence exemption is key, particularly in BC. So other than the principal residence exemption, there's not much that can be done to avoid or reduce the capital gains tax that's going to happen during that intergenerational transfer. However, the probate fees that we discussed. So probate fees are not formally called a tax, but practically speaking, it's BC's form of inheritance tax. There's a lot of planning that can be done to minimize probate fees. And so that's what a lot of my focus as a BC estate planner is on. And in terms of other potential inheritance taxes, there are also real estate specific taxes that can apply. For example, property transfer tax, or foreign buyers tax, speculation and vacancy tax. And so that involves any time real estate is transferred from one person to another. And it takes into consideration things like, you know, is the recipient a Canadian resident person, a Canadian citizen, or permanent resident? So there's unfortunately a menu of several different taxes to consider. But the type of tax to best plan around tends to be that probate fee that we talked about.
Thank you, Catherine. Very comprehensive answer. And we have several questions around the Bear Trust comment that you made and the topic that you covered. And there is 4 or 5 different questions with varying degrees around Bear Trust. So maybe I can just ask you if you could expand or elaborate a little more around Bear Trust and that $50,000 threshold that you noted. And if there are any additional resources that our audience members can refer to get more information around Bare Trusts and how to manage that, adding a joint to an account or not adding a joint to an account.
Yes, so this is a hot topic in recent years. So the starting point is, what exactly is a Bare Trust? Now, when we say a Bare Trust, we refer to a situation where there is a mismatch between who the named owners of an asset are compared to who is the actual owner of the underlying asset. So for example, I've got a joint bank account with my son. And so both my name and his name appear as owners on the account. However, all the money that goes into that account technically belongs to my son. It's for him to purchase video games and whatnot, mostly for college. And so in that scenario, we've got a mismatch of the owners that show on the record, both me and my son, but the underlying owner is strictly my son. So whenever we have that mismatch, we call that a Bare Trust, because I am simply a puppet owner, and my purpose is to hold my portion of ownership in trust for my son. So let's say that that joint account has $20,000, and that's the amount never exceeds that amount at any point of the year. I do not have to file a Bare Trust tax return for that account. However, if Santa is good to us and gifts a lot of cash this year for Christmas, and the balance hits $50,000 or more, then that's going to cause us to have to file a tax return. So these rules apply for the 2023 year and onwards. So you've got to ask yourself, is your account a Bare Trust? And what that means is, who is the underlying owner of the account? Is it both you and the other owner, or is it just one of you? And then ask yourself, what's the balance at any point in the year? Has it reached 50,000? And if so, then I recommend speaking with an accountant or a lawyer about whether a return has to be filed. And another common question is, am I paying income tax because of the Bare Trust? And the answer is no. So you're not reporting any income in the Bare Trust tax return. The policy reason for this is the federal government, they want to know what Bare Trusts exist out there. So the purpose of this tax return is to inform the federal government that this Bare Trust arrangement exists, and they want to know who is the true owner of an asset behind whatever puppet owners might appear on the paperwork. So there's no tax payable. This is simply an exercise of informing CRA that a Bare Trust exists for a particular asset.
That's great. Thank you for that answer, Catherine. Linda, a question around do-it-yourself will kits. There is a lot of online resources. There is a lot of information out there. And the question that comes to us, are these do-it-yourself services good enough for someone with minimal assets, maybe a house and some investments? Or are there risks and things that we should be mindful of when we look into these online resources and do-it-yourself tools?
Thank you, Barry. Yes, there can be some issues with online wills. They are intended for very simple and straightforward situations and beneficiaries. Now, even though your assets might be simple and what you consider to be simple, perhaps the distribution is not. If you have minor children, or if you have children with disabilities that need trusts in place, then those online wills are not going to be helpful for you. One of the things that I do talk about is, if you have an RESP, typically I would suggest that you put a trust in place for your RESP as well, to make sure that a substitute subscriber is appointed to keep that plan open for your children for as long as possible, and then collapse it at some point when it's no longer usable. So again, it depends on your circumstances in totality. It's not just the assets themselves.
Thank you for that answer, Linda. Catherine, a question around dealing with a lawyer. If one deals with one lawyer, do they always have to deal with the same lawyer, or can they work with someone else in the future?
That's a very good question, and the answer is no. There is no obligation to continue working with the same lawyer. So a few things to take into account. If the lawyer already knows a lot about your personal circumstances, sometimes it can be more cost efficient to go back to that lawyer so they can reopen their file and see what notes they have regarding your circumstances. So that's one consideration to make. I think different lawyers have different levels of expertise. So if you've got a general practitioner who does estate planning as part of their practice, they may defer to an estate planning specialist on more complex questions or tax-driven questions and things like that. I know that there are a lot of estate planning lawyers who are in the process of retirement, and so there has been kind of a rejigging of estate planning lawyer appointments, and that's another consideration. But I think the takeaway is that there's certainly no obligation to work with one person for that first will and forever onwards after that.
Thank you for that answer, Catherine. We have time for one last question. And Linda, the question is around principal residence and whether it forms part of the probated assets of a deceased person.
Yes, so a principal residence, if it is jointly held, then on the death of the first spouse, it passes to the surviving joint holder and does not form part of the estate of the first deceased spouse, so it's not subject to probate. However, if it is a principal residence, even if it's in, if it is a principal residence, if it's in one name only, then on death of that person, it is part of the estate and is subject to probate fees. It's not subject to capital gains tax because it's exempt, but it's subject to probate.
Thank you for that answer, Linda. So this brings us to the conclusion of our webinar. A big thank you to Joe, Catherine, and Linda for this informative session. And a big thank you to you, our audience members, for joining us and for your participation in the questions and engagement. As mentioned earlier, a recording of today's webinar will be uploaded to our YouTube channel, and a link of the recording will also be shared with those who are registered through the email link. I just want to highlight one general point here, that the information that you're hearing today is quite general in nature. So we really highly recommend that you seek professional advice when it comes to structuring your estate, whether it's speaking through with a lawyer or a tax expert or seeking the advice of a professional accountant. In addition to that, we want to invite you to book a one-on-one consultation for an estate and wealth planning consultation with our very own Linda Deer. You can book an appointment with Linda directly through our website at vancity.com, and she'll be more than happy to give you additional information and resources that are relevant to your personal and particular situation and circumstances. As Joe mentioned earlier, although this is the last webinar in our series in November, we do plan to put together additional webinars in the new year. So please refer to the link in the QR code that you see in front of you on the slide, and feel free to share your thoughts and feedback around what topics you'd like to see in the future. With this in mind, I'd like to thank all of you for your time today. And big thank you again to Joe, Catherine, and Linda for this informative session. Thanks, everyone, and have a great rest of your day.
Thank you.